Unit 2, Presentation 6, Medical Parole, Geriatric Parole, and Other Avenues. In this presentation, we're going to speak about other forms of parole and ways out of prison other than the general form of parole where hearings are automatically scheduled. So things we'll touch upon include medical parole, geriatric parole, administrative release, other residential programs, and commutations. Let's start with medical parole. The regulations provide that an inmate may be released at any time on medical parole. This means they wouldn't have to have reached parole eligibility in order to be released on medical parole. So this is intended for people who are so, quote, debilitated or incapacitated in their health as to be physically incapable of presenting a danger to society. The application for medical parole is just a letter written to the Parole Commission. It can come from the person themselves, it can come from a family member, it could come from the warden, another employee, someone in another professional capacity. Writes a letter to the Parole Commission and says that they would like to be considered for medical parole, and the Commission will then decide whether to do that or not. It would help to include with the letter as much detail as possible, and if there is some documentation supporting it, put that in as well. However, having said that, this is simply not generously interpreted. Anecdotally, people do have to be right at death's door to get medical parole. It's not just that you're very sick, it's that you're sick and nearly dead. And then the regulations provide essentially that if by some miracle the person's health improves, they can be sent back to prison. Geriatric parole. In Maryland, people over 60 can apply for geriatric parole, but, and it's a very, very big but, this only applies to a small number of people who've been sentenced under Criminal Law Article Paragraph 14, and that is mandatory minimum sentencing. So anyone who was sentenced under anything else simply isn't eligible to even request geriatric parole. It's very few that would fall into this group of people. But if you do fall in that group, you've got to be over 60, have served at least 15 years, and not be a registered sex offender or registrable. And you can write to the Parole Commission and request to be considered for geriatric parole. So the rationale of geriatric parole, well, so in Maryland specifically, it is arguably there to ameliorate the harshness of the mandatory minimum sentencing provisions. But more generally, the concept of geriatric parole, it comes about because old people don't reoffend. That's the bottom line of it. And that is a fact which is not appropriately reflected in the risk assessment tool which is used for parole decision making in Maryland. Remember, we've talked about this in Unit 1 and a little bit more in Unit 2, that the risk assessment is essentially an algorithm, and with any algorithm, what goes in more or less determines what's going to come out the other end. And if you don't factor as an input the proposition that old people don't reoffend, then you're not going to get an output that reflects that proposition. In the 2021 legislative session of the Maryland General Assembly, there was House Bill 426, which required the Parole Commission to develop a dynamic risk assessment tool specifically for predicting reoffending of people over 60. However, the bill died in the committee stage. This graph comes from the Governor's Office of Crime Control and Prevention, known as GOCAP, and GOCAP had a 2019 working group on geriatric parole, and I've included this graph just to show how much the reoffending risk drops off with age. It's not super high for the 60s, people in their 60s, but as they get older, once they hit 65, look, it goes down a ton, and then when they're really elderly, it's almost a non-existent factor. Geriatric parole goes to a cost issue and a dignity issue. elderly inmates cost about twice as much to incarcerate as younger inmates, and this is because of increased health issues. Estimates vary, but they come in around the figure of 60,000 to 70,000 a year per elderly inmate. In that working group report that I just mentioned, GoCap predicted that in 5 years, so the report was in 2019, so by 2024, Maryland's geriatric prison population could have nearly doubled. And the dignity point is that prison is not the place for elder care and end-of-life care, and that's regardless of whatever that person has done. There's another element to the dignity issue as well, though, because it has to be considered from the perspective of the other people who are incarcerated who aren't geriatric. Consider this scenario for a second. You are a person who's not particularly old, young or middle-aged, and you're fairly well in yourself, in your body and your mind, but you are sharing a cell with someone who is in their 80s and who has some kind of degenerative neurological condition, dementia or Alzheimer's, that kind of thing. This is a extremely plausible scenario, and as the cellmate of that person, you're in a very small space with them. You are, if you choose to take it on, as people do, de facto now a carer for a very unwell geriatric person. And so there's the dignity issue of the perspective of the person who's put in that situation, and whatever the rationales given for punishment, that goes back to our philosophy of punishment discussion in Unit 1. Being a carer in a small space for someone with dementia isn't generally part of what we justify incarceration by. So administrative release, this is another route that could be taken that's slightly different from the regular parole. This is where you could be paroled without actually having a parole hearing. It happens because the Parole Commission sets a tentative release date in conjunction with an individual case plan that gets frequently reviewed. If you stay on track with the case plan, then you're going to get released at that set tentative release date. This is only available in respect of certain offences, though. Some property offences, controlled substance offences. Doesn't apply in respect of people who have convictions for violent crimes or sex crimes. But if anyone who thinks they might be eligible for this process should check with their case manager and contact the Parole Commission. Then there's these other residential programs. This is referred to in the relevant legislation. It says that a person may be released on parole at any time in order to undergo drug or alcohol treatment, undergo mental health treatment, or participate in a residential program of treatment in the best interests of an expectant or newborn child. This looks like a great provision, but it seems like it's really not used much at all. And I think that's to do with funding or a lack thereof. Certainly, many people who are incarcerated try to get channeled into drug and alcohol treatment by going back to their trial judge with what's known as an 8505 request to be assessed as to whether transferring them into drug and alcohol treatment would make more sense than incarcerating them. So that's very common that people are asking for that, because they often know that it's that kind of issue that's brought them into prison in the first place, and it's that kind of issue that has to be dealt with for them to be well set once they're released. But that often is not successful. But this channel that relates specifically to parole doesn't seem to be commonly used. Perhaps if the person themselves or their family had significant money and was able to identify a residential program somewhere and document that and line that all up and say, well, we'll pay for it and this is what it is, and brought that before the Parole Commission so it wasn't reliant on any public purse money, then that might be a go. So that provision looks really, really sensible, but I don't think it's particularly heavily used. Commutations. The Parole Commission is responsible for making recommendations to the governor on commutations. To commute a sentence is to substitute a lesser sentence for the one which was originally given. To apply for a commutation, it's necessary to write directly to the governor, who will then decide whether to ask the Parole Commission to look into the case and determine whether or not to recommend the commutation to him. So you write to the governor, who will decide whether to push it back to the Parole Commission, who will decide whether to recommend it back up to the governor. The address is 100 State Circle, Annapolis, MD 21401. A letter should probably address the similar considerations as a parole packet would, the same kind of issues, for example, the expression of remorse and all the different ways in which the person has grown and changed. Appeals. One point it's important that people realise is it is perfectly acceptable to pursue appeal rights at the same time as you are preparing for a parole hearing. Sometimes people aren't clear about this, and I think it's because you are making two very different kinds of arguments. With the appeal, you're often trying to argue for one reason or another you weren't guilty, or there was some other issue with the conviction. At the parole stage, you're not trying to unpick the conviction itself. You're trying to just argue why it's time for you to be released, why it would be appropriate for you to be released. That doesn't matter though. These are just two different avenues. There's no contradiction in arguing the different things because you're arguing using the right format for the right avenue. The Parole Commission is not going to be looking at motions that are filed by way of appeal. Those papers don't go to the Parole Commission. They have enough to look at that they're not going to be seeking to get information from other agencies like that. That said, anecdotally, it does seem that people are sometimes asked at their parole hearing whether they are pursuing an appeal. So be prepared for that question, but recognize that you are perfectly entitled to pursue your appeal. And if the two things are happening at the same time, that is fine.